the transfer of a worker who assists a disabled family member. The Supreme Court, in Order Number 33429 of November the 11th, 2022, made a decision on the transfer of a worker who benefits from the permits under Article 33, Paragraph 3, Law Number 104/1992. Pursuant to Article 33, Paragraph 5 of the aforementioned law, a worker who assists a disabled family member and thus benefits from the permits referred to in Paragraph 3 of the aforementioned provision cannot be transferred without their consent. According to the court, this means that the interest of the disabled person prevails over the ordinary productive and organisational needs of the employer, but it does not exclude that the same interest, even if it prevails over the aforementioned needs, must be reconciled with other relevant interests other than those underlying ordinary mobility. For the purposes of the concrete application of Article 33, Paragraph 5 of Law Number 104/92, therefore, it is necessary from time to time to verify the opposing interests and carry out a fair balancing of them. In particular, in examining the case at hand, the judges held that the enhanced protection to which an employee who continuously assists a disabled family member is entitled to operates with respect to the ordinary technical, organisational and productive needs that legitimise mobility, with the limit of the suppression of the position or other situations, in fact, insusceptible of being otherwise satisfied. Consequently, in the concrete case, it held that the established suppression of the job position, along with the worker's refusal to accept a different task, was sufficient for the transfer to be considered legitimate, despite the worker's lack of consent. Moreover, in the order under review, the Supreme Court ruled on another important principle, namely that the entrepreneur does not bear the burden of proving, in the case of a transfer, the impossibility of relocating the employee who assists the disabled family member, as they would be required to do in the case of dismissal for objective justification. The court ruled on this point that transfer and dismissal of the employee remains an ontologically different phenomena in nature and scope. Hence the impossibility of considering that, in these two different cases, the burden of relocation can operate in the same way. Sara Lovecchio, lawyer.